Okay, we are into defamation of character. We're on page 118 of the study guide. We've talked about the difference between invasion of privacy and defamation, but now we're going into defenses to defamation of character. Well, the three criteria are it's a false statement, injuring a good person's name or reputation by being communicated somehow through a third party to injure that good name or reputation. The first offense is it's true. If it is true, it cannot be false, therefore it's no defamation. So if I say to somebody, if I accuse someone of being, say, the biggest slut in Texas A&M history, first of all, that's an opinion based. So if I just, let's just change that. We'll come back to that one a little bit later. But if I say something and it turns out it's actually true, okay, it's actually true, then it's not defamation. It's got to be false and injure the good name or reputation. If it's true and injures a good name or reputation, the only thing they could possibly sue me over is how did I get that information, i.e. invasion of privacy, crap, but definitely not not defamation, okay? So if you're given storyline multiple choice answers on the exam with a defamation, if the statement was in fact correct, or it was later found to be accurate, or the true statement, all of those are not defamation, so you can eliminate those as possible answers, or unless the question is which is not defamation, then those are going to be the answers, okay? So first thing is defense. Then there's privilege. Certain times there's privilege. There's an absolute privilege that if you are being honest and truthful, whether you're right or wrong, if you're being honest and truthful in court, then public policy such as testifying in court would be absolute privilege. So if someone was to put me on the stand because my neighbor committed a murder, and I said, I saw him murder that person, and he's later exonerated, the jury finds he is not guilty. And so he's found not guilty by a jury of his peers. And in the criminal case, that'd be beyond a reasonable doubt, and everything like that. Then he decides, you know what? That guy said I did it when the jury says I didn't, therefore I'm going to sue for defamation. Well, if I say I did it and I wasn't trying to lie or commit perjury and I was doing it as my honest and truthful answer, then that is absolute privilege, and I would be able to defend myself if he sued me for defamation. The next one is constitutional privilege. This is Senator Proxmire's Golden Fleece Award. And he might have talked about this in class before before spring break and stuff like that. But if a statement is made by a legislator or other public officials, but mainly a legislator, it is going to fall under an absolute privilege called constitutional privilege. It is an example of an absolute privilege that's going to be constitutional. Within their job description as a legislator or other public official, but as a legislator, they have the right to say certain things, and if in fact it is false, they will still be able to defend themselves from a defamation of character lawsuit. Now, this is limited, and this is limited because of the Hutchinson versus Proxmire case. Now, this case is more of a tier 2. It's similar to what you might have had on your first exam with the fishing bait, where he didn't give you the names of the cases, but you need to know the storyline. But the Golden Fleece Award, Senator Proxmire's Golden Fleece Award, was all about this. If a legislator makes a false statement, say about Trump and his domestic policy or foreign policy or something like that, and it's later proven to be false, it's probably going to fall under constitutional privilege because it was a statement made by a legislator acting within his job description. If, however, that same legislator is trying to filibuster and just talk so a bill doesn't go to a vote, and keeps talking and finally runs out of things to talk about and says, oh, you know, my roommate had sex with goats back in college. And everybody Googles his roommate's name and it turns out to be you. And now all of a sudden your good name or reputation is injured because you didn't have sex with a goat. Then you could possibly sue and he would not be protected from constitutional privilege because it doesn't fall under his job description. Okay? What if you did have sex with a goat in college? Then it would be true, so it wouldn't be false. So you couldn't sue you couldn't sue him for defamation there, and he wouldn't even be able to use constitutional privilege. Okay, but understand, legislators making statements that may be false may have constitutional privilege protection, depending on if they stay within the framework of their job description. The next one is conditional or qualified. If a statement is made in good faith with proper motives, if a statement is made in good faith with proper motives, and notice at the very bottom, page 118, study guide, it says can be no malice, because there can be no malicious action taken. And you're recognizing to protect someone's interests. And it's a good faith statement with proper motives. If it is false, it could arise to be conditional or qualified in nature. Let me give you an example. Say, for instance, a doctor calls the wrong patient to give them test results. And those test results, which are obviously for a different patient, are overheard by a third party. And now they know either they have syphilis, gonorrhea, or whatever, or they're, whatever. The story I like to give in class is, say, and I'll pick out a student, I say, this person is having sex with this person on the down low, unbeknownst to their wife. Okay, so they're having sex with another man, unbeknownst to his wife, she doesn't know. The other guy gets tested for HIV, AIDS, or whatever, and is found out to be positive. The doctor then calls up the husband and says, you might want to get tested. Your partner has been found to be HIV positive. Let's go ahead and get tested, because he says he's only had sex with you on the down low. Now, if that guy hears about it, there's no defamation, there's no issue. But what if his wife overheard that story? Not only would that be, a possibility of invasion of privacy, because she read over his, voicemail, or overheard his voicemail, it can maybe sue for invasion of privacy. But then, what if that wife gets mad and takes a baseball bat to him and hits him, breaks his arm, or whatever? We have assault, we have battery. Even if she's just 5'5" and nothing pounds, and he's a much bigger guy, if she takes a baseball bat to him, obviously the average person would consider that to be assault and battery probably. But then the guy is ticked off about all the injuries he has, so he sues the doctor because he finds out the doctor sent that information to the wrong guy. Okay, so now he wants to sue the doctor for making a false statement, injuring the husband's good name and reputation by accusing him of having sex on the down low with another man. And he injured his good name and reputation with his wife because she overheard that information, correct? Well, the doctor didn't do it with malice. He was doing it to protect interest. He could maybe argue conditional or qualified. Now, those can be on separate lines of the exam. Conditional can be on line A, qualified can be on line C. And if that is the correct answer, A and C would both be correct. So you need to be ready. I think most of y'all now, if you're even just coming for exam 2 to the review or listening to this review, you know what I'm talking about with the A and B but not C, C and A but not B, all the above but D type questions that SWIM has. That would be conditional or qualified. No malice, there cannot be any malice. A statement made in good faith with proper motives. Now, what if that doctor wanted to desperately date your wife and he was hoping to get y'all divorced so he could go out with her? Then he has non-proper motives and he made that statement with malice, knowing it was false, to injure your good name or reputation, to maybe get y'all to divorce and stuff like that. Then he would not have the defensive conditional or qualified privilege. Now, this storyline, doctor storyline, if he gave it to you in class, he has used it on the exams before, and you might have heard this story. There's another story which I'll go to a little bit later on. Well, actually, it was invasion of privacy. It was a story that he usually gives in class sometimes about naked motorcyclists. There's one question in the back of the study guide about it. So people are riding motorcycles naked on Texas A&M campus, and it runs out of gas. Then they can then sue for invasion of privacy if people take pictures of it. Because there's no expectation of privacy, there's no invasion of privacy. Okay? Same basic idea here for conditional or qualified, good faith, proper motives, no malice. All right? Now, in Texas, we have on page 119 at the very top, we have all the different things in Texas for the defenses as well and how defamation occurs. I don't think you really need to know too much about that other than at the very top, number 2, on page 119 of your study guide says Texas does not allow defamation of dead people, does allow defamation of dead people to be actionable. So if I injure the good name or reputation of someone who is already dead, their heirs, their family could sue me under defamation. Many states, my reputation dies when I die. My good name and reputation dies when I die. But in Texas, if you injure someone's good name or reputation, even if they're dead, you can still sue in Texas and sue for defamation and win. So I would note that for the test. If he gives you a storyline in Texas, okay, and someone has died and you make false or disparaging statements that turn out to injure that person's good name or reputation after their death, then that could be defamation of character as well. Now, if you say it in spoken form, that's slanderous. If you say it in the written form, that would be libelous, correct? Just note that for the test as well. But Texas does allow defamation of dead people to be actionable, meaning you can sue. Okay? Now, if it's a newspaper or a broadcaster, that is either going to be recorded speech and or written speech, so that would be more libelous in nature as well. Okay? So now we have talked about assault and battery. We've talked about false imprisonment. We've talked about infliction of mental distress. We've talked about invasion of privacy. We've talked about defamation of character. Now, we have the next one on page 119, in the middle of page 119 of your study guide, called malicious prosecution. In Texas, we also call this tort of abuse. You could use those interchangeably. The definition is the wrongful use of a legal proceeding, either civil or criminal. In order to win, you must win all lawsuits against you. Then you must prove the opposing party had no probable cause, must then prove malicious conduct. So, going through just malicious, what does it mean by malicious? You intended to do it without any regard for anything. Do public figures have to show malice for invasion of privacy? No, they just must show that it's their private life for public figures. They must show malice for defamation of character. We also must show malice for a malicious prosecution case as well. Okay? You must prove that the opposing party had no probable cause for the lawsuit and must prove malicious conduct by them in order for it to occur. Now, we call this the tort of abuse of process in Texas, or we have one similar called abuse of process. And the state of Texas does not favor this. But let me give you a scenario for a situation on the exam. And this is one of the least likely of the 8 personal intentional torts that's going to be on your exam, but you still could have a question. Say we have a situation, say we have a preacher who comes out of Walmart, and as he's leaving Walmart, 2 Walmart employees run out yelling, "Stop thief," and start running through the parking lot. Now, the guy knows it's not him. He knows a couple of guys running past him earlier, so he knows they're going after him. So he's not in any fear that it's him or anything like that. So he just goes on his merry way. But then all of a sudden, he hears "Stop thief," and they're right behind him, and they're about to get him. So he starts to run because now he thinks they're coming after him. They then catch up to him and tackle him to the ground and drag him back to Walmart until the police arrive. Now, they are mistaken. He didn't commit any kind of shoplifting, okay? Could he then sue for assault, battery, false imprisonment on all those potential situations? Yeah, assault because he saw the fear coming, okay? Battery because he was tackled to the ground. False imprisonment, he was dragged back to the thing and maybe detained until police arrived, depending on how long it was. You could have false imprisonment as well. So then he decides to sue because not only was his good name injured, because defamation, think about it. Say this is a preacher and people in his congregation are in that parking lot, and over here people say, "Stop thief,"